Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are getting into verdicts and settlements, specifically jury verdicts for fusion cases. And so this is an interesting topic, and I got access to a new database because a lot of the prior videos I've done were confined to one specific database. You know, there's LexisNexis, there's Westlaw, there's also something known as the Jury Verdict Reporter and Verdict Search. So now I've gotten access to more databases, and these are national. So it's a little bit better for you guys, for the viewers, right? Because it's not just limited to New York, but it's the entire United States of America. And so I just thought I would test this out. So I ran a search. And this particular search is known as, you know, a lumbar fusion, because when you do the search, it actually has type of injury, and it has, like, you could choose the injury. And under back injury, it had a choice of a lumbar fusion. So I put that down, and this is what came out. And I sorted it by date, meaning the most recent and on down. So let's see how many we can get through. So here's the first case. And you guys could guess it. I won't tell you the verdict until the end, so it'll make it a little bit more interesting, a little bit suspense. You know, you could guess the verdict. Here's a case. This one was actually a settlement. A truck driver had multiple surgeries after falling into an excavation. And this one actually happened in New York, and it was in New York County, which is Manhattan. So what happened here was that it happened in 2019. The plaintiff was a 37-year-old truck driver. He was working at a construction site on Bleecker Street, and the project involved a renovation of a New York University building. That's NYU. And so there was a construction company that was the general contractor, and they hired this plaintiff's employer to excavate the roadway, which was owned by the city of New York. And so let me see, I have to actually hit view document to see all the information. Okay. So it was owned by the city of New York, right? So what happened was, as part of the job, the workers would place heavy steel plates over the excavation at the end of the day so that the road could be reopened for traffic. And in the morning, the plaintiff and his co-workers would use an excavator to hoist the plates off the roadway so they could resume the work. And on a specific day, September 12th of 2019, the plaintiff was standing on the corner of the plate during this hoisting process. And while the steel plate was 1 to 4 feet in the air, the plate suddenly moved downward. So the plaintiff lost his balance and fell into the excavation, which was 31 inches deep. And he claimed injuries to his elbow, ribs, back, neck, shoulder, and knees. And so he brought a lawsuit against the city of New York, the New York City Department of Transportation, New York University, and Turner Construction, which was the general contractor. And the lawsuit alleged that the defendants negligently failed to provide a safe workplace. The lawsuit further claimed that the defendants' failure constituted a violation of the New York State labor law. Now, the labor law is just basically a gravity-related statute. If you're falling from a height as a worker, if you're falling, or if a falling object is being hoisted or secured, if the falling object falls and hits you, falling worker or falling object, and then it's strict liability. So the attorney for the plaintiff moved for summary judgment on liability, and they argued that the accident happened because of an elevation-related hazard as defined by Labor Law Section 240, and that the plaintiff was not provided the proper and safe equipment that is required of the statute. And the plaintiff specifically argued that his employer had instructed workers to stand on the corners of the plate to keep it level while it was being hoisted. And the defendants also moved for summary judgment, and they argued that the plaintiff fell from an insignificant height, 31 inches, so it's less than 3 feet, and that Labor Law 240 was therefore not applicable, that it's only applicable to, like, larger heights. And the defense further argued that the plaintiff was the sole proximate cause of the accident because he had allegedly failed to use readily available safety devices. Now, they don't say what those devices are, like hoists or what was available, but they always argue that, the defendants, because if it's found by the court that the plaintiff is the sole proximate cause, that means the only cause legally of the incident, well then, you lose. You can't sue the defendants anymore. So they always argue that. And so at the time of this mediation, the motions were still pending before the court. And I recognize some of the names, like the orthopedic surgeons. I've used them myself. The economists I've used. I recognize the attorneys. So yeah, that's basically the case. I mean, the case was a lumbar fusion. The lumbar fusion was for a herniated disc at L5-S1. There was also a, let me see if there's more information about the injuries. Oh yeah, here we go. There's more information about the injuries. So after the accident, the plaintiff complained of left rib pain, left elbow abrasions. He went to the trailer, the construction trailer, to get first aid. He was then taken to a walk-in clinic. He was treated and released. He then went to, returned to the job and finished his work shift, but he had bulges in his neck. He had injuries in his thoracic and also his lumbar, and he had the herniation at L5-S1 with radiculopathy, which is the radiating pain that travels from that L5-S1 lower back disc down to the legs. And he was also diagnosed with a partial rotator cuff tear, and he had impingement of the shoulder. A right knee MRI showed a meniscal tear, and so he basically did pain management, physical therapy. He tried lumbar epidural steroid injections, thoracic and lumbar trigger point injections, cervical epidural steroid injections, sacroiliac joint injections, lumbar medial branch block injections, cervical radiofrequency denervation, and a sacroiliac radiofrequency ablation. That's like when they burn the nerve so you don't feel the pain because the nerve is being impinged on by the herniation. So if they burn it, you don't feel the pain. Due to the ongoing symptoms and failure of all this conservative care, he had multiple surgeries. The first was in 2020, was for the left shoulder. It was an arthroscopic, which is a synovectomy, bursectomy, subacromial decompression, and debridement. Then in August of 2020, he had a lumbar discectomy and fusion, which was a decompression, laminectomy, bone grafting, and annuloplasty. And then the following month, he had a C4 and 5 discectomy and arthrodesis with hemivertebrectomies. Oh, so he had a C4, C5 discectomy and a lumbar discectomy and fusion. Then in December of 21, he had a left knee arthroscopy. And yeah, so he had a meniscectomy, synovectomy. So he had a lot of surgeries. And then he continued to experience pain to the neck, low back, left shoulder, knees, and he was claiming medical care in the future, including medications, physical therapy, imaging studies, follow-up appointments, and additional surgeries in the future, which is always, a good idea to do if you're going to have a permanent lifelong injury. You want to show that it's not just going to go away, it's going to be into the future. This is a young guy, 37 years old. And he sought recovery of past and future medical expenses and damages for his past and future pain and suffering. So, and I also recognize the judge. This was an arbitration, and I recognize the judge. I've had many cases with him. He's a pretty good judge. So, can you guess the settlement? This was a settlement at mediation. Can you guess the settlement? This case settled for $5 million. Not bad. It was a pretty good result, I think. $5 million. I mean, serious injuries, cervical and lumbar surgeries, including shoulder and knee, and $5 million. I think, pretty good settlement for all the parties. Okay, let's do the next case. I'm gonna open up the PDF in another window because it seems like when you're in the actual website, what it does is it throws you, it doesn't give you all the information. So what happens is if you want all the information, you then have to click and then it's so slow in loading. So I'm gonna go back and just open up a PDF of everything. That way it's a little cleaner. Let's see. Okay, here's another case. And this one was also in New York. I don't know, this is just by, I guess the most recent cases happened to be in New York. But this one was a bus caused a chain reaction collision that led to surgeries. And so what happened here was, this was a trial, and this trial happened on December 20th of 2023. So fairly recent, fairly recent trial, 2023, just, a month or two ago. And this was, I also recognize a bunch of the doctors. I use these guys, doctors and the economist, excellent. And I know the plaintiff's lawyer, a good plaintiff's lawyer. Okay, so here's what happened. On September 5th, 2018, the plaintiff, who was a 46-year-old Verizon employee, was driving a car in Juniper Boulevard in Queens, New York. And so he stopped for a red light, and then the defendant was operating another car behind plaintiffs, and then there was also somebody else operating a Metropolitan Transportation Authority, MTA bus, behind this other lady's car. And so the bus struck the rear of this other car, and then, so that car then was pushed into the plaintiff. So it's like a 3-car pileup. The bus hits the middle car gets pushed into the plaintiff's car. And so the impact pushed the plaintiff's car approximately 40 feet into the intersection, and the plaintiff alleged neck, back, shoulder injuries. So the plaintiff sues everybody. He sues the middle car, he sues the driver and the MTA and the New York City Transit Authority, the MTA bus company. And by the way, that's good, because when you're dealing with these buses, it's a little bit of a trick. They use it as a sword sometimes. Like, they have all these different companies. Some are Metropolitan Transportation Authority. Some are MABSTOA, the Manhattan and the Bronx. Some are the New York City Transit Authority. But some are the MTA bus company. So for example, if you have a bus and the police report could say, hey, New York City Transit Authority. So you go ahead and sue the New York City Transit Authority, because that's what the police report says, but it's really owned by the MTA bus company. They'll make a motion to dismiss, and very often it can be granted, and you lose the entire case because you didn't sue the right entity. But how are you supposed to know, how they control, they have all these companies, how are you supposed to know who owns it if the police officer gets it wrong on the police report? It's a crazy law. They really should fix that, but unfortunately, so the best practice is just to always name all these entities, because you never know. But anyway, that's just a side. But so the plaintiff sued, the middle car and the driver of the bus, and he argued that they were negligent in operating their respective vehicles, and that the remaining defendants were vicariously liable for the bus driver's actions. And so the middle car filed a motion for summary judgment, and the plaintiff also filed a motion for summary judgment on liability, and both motions were granted. So the plaintiff won on liability, meaning that the bus driver, shouldn't have hit the middle car. It's a rear end, so clear. So he won on liability on summary judgment. It was granted. But the middle car's motion was also granted, because she's like, well, I'm just the middle car. I'm stopped. This bus comes, hits me. Of course he's going to push me into the plaintiff's car. What did I do wrong? So she's out of the case. Her motion was granted as well. And so the remaining defendants were vicariously liable for for the bus driver's actions. So I guess that what happened was the case proceeded to trial on the issue of damages against the remaining defendants. And during the trial, plaintiff withdrew his claims against the Metropolitan Transportation Authority and the New York City Transit Authority. Oh, you see, I was right. Why did he do that? Because the real party in interest was probably the MTA bus company. You see, you sue everybody, but then you just withdraw against the MTA and the New York City Transit Authority, because those entities didn't own this specific bus. This specific bus was probably owned by the MTA bus company, which is a separate legal entity. And so in terms of injuries, so remember, this is a damages only trial. In terms of injuries, the plaintiff went to the hospital from the scene. He was diagnosed with an L5-S1 herniation with an annular tear. He claimed an L1-2, L4-5 bulge, lumbar radiculopathy, facet synovitis, lumbosacral derangement, posterior paraspinal fasciitis, loss of lumbar lordosis. Okay, so he had a C5, C6 herniation, a C6, C7 bulge with radiculopathy, which is the radiating pain from the neck going down to the arms. He then also had, he injured his shoulder. He had a thickness tear of the supraspinatus tendon along with the shoulder derangement and decreased range of motion. He had lumbar epidural steroid injections in 2019. He also had arthroscopic shoulder surgery that included a debridement, subacromial decompression, distal clavicle resection, and lysis of adhesions. And then he also had a bilateral facet joint injection in 2019 and lumbar medial branch blocks in August of 2019. Physical therapy, chiropractic treatment. Now, he had lumbar surgery in October of 2019, which was a lumbar laminectomy included with medial facetectomies and arthrodesis, bone grafting. He received additional bilateral lumbar injections in June and March. So June of 21 and March of 23. So that was the major surgery, was the laminectomy. That's when the lamina gets removed from the spine. It's a pretty serious surgery. And the facets, which is those circles, the facets where the nerves are exiting or entering, those get opened up. And that way the nerves don't touch and don't impinge. And so the plaintiff testified he never had any prior accidents, never missed any time from work before the crash. His attorney argued that he required additional pain management treatment, diagnostic testing, physical therapy, doctor's appointments, medical equipment, medications, and surgery. And the plaintiff specifically claimed that he requires an adjacent level lumbar fusion and a cervical discectomy infusion. So he was injured at this one level, and now he requires an adjacent level fusion, which is adjacent disc disease. That's very common. That happens a lot. And I guess his doctor said, look, he's going to have this adjacent disc disease. He's going to need another fusion at the next level. And so, you know, you got to claim it, because if you don't claim it now, then later he's going to have that fusion. That's like a $100,000 surgery. No one's going to pay for it. So it was smart to claim it. And so it says that the plaintiff sought recovery of future medical expenses, past and future lost wages, and damages for his future pain and suffering. So the defense counsel argued that the plaintiff did not suffer a serious injury under the no-fault law, which is insurance law 5102D. And the defense argued that plaintiff only suffered sprains and strains in the crash and had pre-existing conditions unrelated to the crash. And so the jury determined that plaintiff did sustain a significant limitation or use of a body function or system, a permanent consequential limitation of use of a body organ or member. So basically they said that he qualified for the serious injury. You have 9 different categories. If you meet any one of them, you qualify. But here I think he met numerous categories, including the 90-180, which is if you get a non-permanent injury or impairment that prevents someone from performing substantially all of the material acts which constitute the usual and customary daily activities for 90 out of the first 180 days. So 3 months out of the first 6 months, right? The material acts that you usually do. I don't know, people who write these laws, they're a bunch of nerds. They use these big words. Who talks like that? Impairment that prevented his performance of substantially all of the material acts that would have constituted the usual and customary daily activities. I don't know. Just basically say, you can't do what you usually do. What do? I go to work. I go to school. I go to the gym. I hang out with my family. Can you do that? No. Is it a little bit of a limitation? No, it's a big limitation. I can't do anything, you know. They gotta make it simple so people could understand. They're using these fancy language. Who's this for? Anyway, guess the verdict. So this was a verdict in Queens, like I said. And can you guess the verdict? The verdict was actually for $23,360,765. I don't know if you guessed that. That was a pretty good verdict for this injury. And so it was broken down as follows. It was $450,759 for his past lost earnings, $5 million for his past pain and suffering, $25,000 for future orthopedic appointments, like medical care for the future 26 years. $488,000 for future surgeries, also for 26 years. $100,000 for future pain management for 26 years. $149,000 for future physical therapy for 26 years. Everything's for 26 years. That's just what the jury believed, you know, how long he would need the medical care. $314,000 for future medications for 26 years. $11,000 for future medical equipment for 26 years. $94,000 for future diagnostic testing. Now, by the way, it's not $94,000, it's $94,904. You know, I'm just not giving you to the penny. I'm just kind of rounding it off. Now, this is the big number, $15 million for future pain and suffering for 26 years. So you can see the pain and suffering, that's what I always say, that's what I always preach, right? If you look at my prior videos, is that the big numbers are going to be the pain and suffering for the past and the pain and suffering for the future, meaning from the date of the crash up until the date of the trial, that's the past, and from the date of the trial for the rest of your life, that's for the future. And they are, right? The past is 5 million, the future is 15, so that's 20 million right there. The other 3 million is lost wages, as well as all these medical expenses. The big medical expense is $488,000 for future surgeries. But he's got a few other big ones. He's got $300,000 for medications. He's got $150,000, $100,000. And then he's also got $1,725,792 for future lost wages or lost earnings for 26 future years. So kudos. This was an awesome award. I bet you this is going to get appealed. I mean, but he could probably get a settlement. I don't know how much. Well, I guess, yeah, it's good because it's against the, it's still against, you know, no matter which company it is, it's still the MTA or the New York City Transit Authority. So there's no limit, right? So it could be a big, I'm sure they'll appeal it, ask to get it reduced, but it's still, you know, there's not like they only have a limited insurance policy. It's unlimited because it goes against their budget. So that's, in that sense, it's good. And it says here, oh, there's a little more information here. It says here that, I know the judge also, I've had some cases with this judge. This was in Queens, like I said. The trial was for 12 days. The jury deliberated for 2.5 hours. The jury voted 6-0. There were 2 men and 4 women on the jury out of the 6. And the offer was $2 million. So the plaintiff's attorney had to turn down $2 million, right, and take a verdict, which was kind of ballsy. That's good. And the demand, or, you know, how much he would have taken to settle before the verdict was $12 million. So, and it says, yeah, the defense counsel filed a motion for a new trial. So, yeah, good result. Okay, let's do 1 or 2 more cases. We're already at the 22-minute mark. Wow, I got my little clock timer here. Every time the sand runs out, half an hour expires. So I use it to keep track of time. Otherwise, you know, you got to budget your time so you get things done in the office. So here's a case. Okay, this is a plaintiff tipped a portable toilet, and this led to injuries of legs and back. This is in Texas, Travis County. Travis County, I believe, is near Austin, where I went to school. I went to the University of Texas at Austin, and I believe Travis County, if my memory serves me correctly. Yeah, Austin, Texas. So let's see what this case is about. Let's read I don't know the doctors, I don't know the lawyers, because, you know, I went to law school there, but that was a while ago. I haven't really, although I am admitted in Texas as an attorney, I can practice there, but I haven't really done much there. So yeah, I haven't really, so I don't know any of the players. But here's, okay, February 15th of 2020, the plaintiff, and he was in his early 30s, he's a pipe fitter, and he was in a portable toilet at a construction site. And the defendant backed into it in a dump truck, knocked it over. So he was in the course and scope of his employment with defendant's trucking company. Now, the concrete subcontractor, which allegedly placed the portable toilet, settled before trial. They don't say for how much, so they're out. I guess, you know, you didn't place it, so if the truck hits it, it's not going to, like, fall over. Now, the general contractor, which allegedly authorized the placement of the portable toilet, also settled before trial. Now, the only defendants in the case at trial were the defendant, the guy who backed the truck into, and his employer, right? So that company, it was a trucking company, a dump truck company. They were the only defendants. And plaintiff's counsel argued that only they were negligent. The defendant's commercial driver's license was from Honduras, not the United States. And the allegations included negligent hiring and gross negligence by the trucking company. Like, why'd you hire this guy? He doesn't even have a license. It's like he's from Honduras. And it's a construction site. You know, you have to be careful with real truck drivers. So the defense denied gross negligence and argued for 25% responsibility each on Gomez and on the trucking company. I'm sorry, no, they argued 25 each for all four, right? So there's Gomez, I'm sorry, that's the truck driver. There's the employer of the driver who knocked over the toilet. There's the concrete subcontractor. I guess they were allowed to, you know, argue they were at fault even after the settlement because they said 25% on the concrete subcontractor who settled and also the general contractor who settled. So they were saying do 25, 25, 25, 25. And so this truck driver, he had his Honduras CDL for 42 years and was experienced and well qualified. That's what the defense argued. And so the injury, what happened was he knocked down this portable toilet, and the plaintiff claimed that he didn't just knock it down, but he also dragged the toilet 15 feet, and he said he was standing when the incident occurred. He went to an occupational medicine clinic 10 days later and ultimately claimed herniated discs at L4, L5, and L5S1 with radiating pain, numbness, and tingling in his legs. He treated, and his medical care included extensive physical therapy, lumbar epidural steroid injections, and in October of 2021, he needed a lumbar fastectomy, foraminotomy, discectomy, and fusion, and the surgery left a scar. Now, it doesn't say like what levels. Well, I guess, I'm sorry, probably the levels where he had the herniations, which are L4, L5, and L5S1, so 2 level. His treating neurosurgeon said that the plaintiff would probably develop adjacent disc syndrome and need another fusion. So same as the last case, okay? And the plaintiff testified about being unable to go horseback riding and go out dancing with his wife. And he was looking for $152,000 for past medical expenses, $423,000 for future medical expenses, $329,000 for past physical pain, $4 million for future physical pain, $329,000 for past mental anguish, $4,117,000 for future mental anguish, $329,000 for past physical impairment, $4,117,000 for future physical impairment, $7,872 for past disfigurement. I don't know where they get the $7,000 for disfigurement. I guess the surgical scar, they thought it was worth $7,000. I don't know. This is, by the way, this isn't the verdict. This is what the plaintiff was looking for. This is what I guess his attorney asked for of the jury. And $411,000 for future disfigurement. Oh, I see. Past disfigurement and future disfigurement. So the big number was future, of course, because he's a young guy. So the total, you know, for everything that they were seeking was $14,334,752. So a significant amount. Now, the defense, what the defense did was they had a surveillance video of the plaintiff and argued that his testimony exaggerated his pain and impairment, and they also argue that the surgery was unrelated to the incident. It doesn't say what the surveillance video showed, but that's known as sub rosa. I guess it showed something. And the defense argued that the jury should award $24,000 for past medical expenses, $25,000 for past physical pain, $25,000 for past mental anguish, $25,000 for past physical impairment, $3,000 for past disfigurement, and $0 for everything else. The defense suggested other greater amounts if the jury believed the surgery was related to the incident. And so the jury found negligence and comparative responsibility, and they gave 40% to the truck driver, you know, who knocked over this porta potty, 35% on the truck driver's employer, 15% on the general contractor, and 10% on the concrete subcontractor. And the jury, okay, that's the verdict. I'll let you guys guess. What do you guys think the verdict was? Okay, so actually the verdict in this case, the total verdict for everything, the jury determined that the plaintiff's damages total, this is a total verdict for everything. It was $170,000, so it was very, very low. So I guess that sub rosa, that video probably did not help the plaintiff, because I don't see, if they're asking for $14 million and they're getting $170,000, that's a big difference. Now, the trucking company was jointly and severally liable for the entire amount. However, the trucking company and the driver were entitled to a $130,000 credit because plaintiffs settled with those other companies, so the general contractor and the concrete contractor. and the jury did not find any gross negligence. So, yeah, they gave pretty low amounts. I see it's broken down here. Basically, 50 past medical costs, 10,000 future medical costs, 25,000 past physical impairment, 15,000 future physical impairment, 25,000 past physical pain, 10,000 future physical pain, 25 past mental anguish, 10 future mental anguish, 170 total. Very, very low. And before, the demand was 1 million. That's the policy. So they were just looking for the 1 million policy. And the offer was 225,000. So the offer was actually higher than the verdict. They should have taken the 225. It's better than 170. And then plus the defendants get this credit. I don't know exactly how that works in Texas because of the other settlement. So they might even be less than 170. So that's not good. Okay. Let's do maybe one more case. Here's a case. This one is a ceiling collapse that led to neck and back injuries. This one also is in New York. So a lot of these are in New York. I don't know why. Maybe because I'm in New York, they're giving me New York cases. Because all I put in was lumbar fusion, I swear. I didn't put in any state, so this could be anywhere. And I did it by most recent. You could also do it by, highest verdict, but then I don't want to get, unrealistic. Maybe the highest verdict is like 100-something million, and I don't want people to think that every case is going to be that big. So anyway, so this is a settlement also. What happened here was a ceiling collapse. This was a case actually in New York, in the Bronx. This was from November 27th of 2023. What happened here was that back on December 9th of 2015, the plaintiff, who was a woman named Kathy, she was unemployed. She was a tenant in an apartment building in the Bronx. And while she was in her bedroom, the ceiling collapsed, caused her to fall to the floor. She alleged injuries to her neck and back. She sued, the landlord of the building, and she claimed the defendant was liable for a dangerous condition that caused her injuries. And she argued that the collapse resulted from a long-standing water leak that had compromised the structural integrity of the ceiling. She maintained that she had complained about the leak and that the defendant failed to fix the leak. And the defense argued that it had no notice of any pre-existing water leak. And and so on the date of the incident, the plaintiff went to Lincoln Hospital's emergency room by ambulance. She alleged a C5 and C6, as well as an L4 and L5 herniation with radiculopathy. So the C will be radiating and traveling pain to the arms, and the L, the lumbar, will be a herniation, traveling pain to the legs. And she initially received conservative treatment that included physical therapy and a cervical epidural steroid injection. And then she also had an anterior cervical discectomy and fusion in September of 2016. And in September of 2017, she had a lumbar fusion with laminectomy, decompression, annuloplasty, and discectomy. She additionally received a trigger point injection in 2018. So she claimed that she has ongoing limitations that prevent her from performing all of her activities that she did before the incident. And her doctors gave the opinion in her report that she requires future doctor appointments, physical therapy, medications, imaging studies, along with additional lumbar and cervical fusion surgeries. And the defense, they had their own neurosurgery expert, and his opinion was that the plaintiff injuries were degenerative conditions not caused by the incident. The expert maintained that the plaintiff's diagnostic studies did not show any traumatic findings. And the expert concluded that Kathy required no future treatment and can perform her usual daily activities without restrictions. And so the parties negotiated a pretrial settlement. And I don't know if you guys want to guess the settlement based on all of what I read, all of these injuries. I know the insurance carrier, I know the defense lawyers, I know the plaintiff's lawyers. I pretty much know some of the doctors, although I don't know the surgeon, but I know the economists. And, oh, I'm sorry, that wasn't the surgeon. It doesn't list who the surgeon was for the plaintiff. It lists who the expert was for the defendant, their neurosurgeon. I don't recognize him. I don't know his name. It doesn't ring a bell. But anyway, can you guess the amount? Here, the amount was $2,200,000. So a pretty good settlement, you know, pretty good, not bad. That's a settlement, so it's guaranteed, as opposed to a verdict. You know, it could be 20 million, but you're not going to get 20 million. They're going to appeal. The appeal is going to take 5 more years, and then who knows? The appellate division might say, you know what, 20 million is a lot. How about you take 2? Well, you could just take 2, right? And it's guaranteed money. So sometimes a settlement is better than a verdict. But okay, in terms of how it happened, so the defendant's primary insurer tendered its 1 million, and then they had an excess or umbrella policy, and they paid an additional 1.2 million. So the total was 2.2. So there was no trial. This was all, you know, pre-settlement mediation. Okay, I hope this was helpful. I guess we could call it for, you know, for now, and then we could do a few more videos. I'm just looking at this document. There's more cases, so we could do a few more videos and cover a few more cases. This is for lumbar fusions. We could do some more. We could do some cervical fusions. We could do traumatic brain injury. We could do burn injuries. We could do arthroscopic knee surgeries, arthroscopic shoulder surgeries. And if you guys have a specific part of the body or a specific injury that you want me to do, just let me know. I'm happy to do that. So please like and subscribe to our channel. Let us know what videos you want to see. If you have a question, just comment in the channel. You can also text me if you want a private, personal, free, confidential consultation, and that is 347-566-9595. I'm happy to do that. I've already done one today, and it's Monday today. It's actually a holiday. Today's President's Day, but I'm working. You see, I'm working. I'm doing the videos. I'm going into some consultations with clients. I'm also doing some other paperwork and planning out the rest of the week. So we're working hard for you. Our goal is helping serious injury victims and families. Okay, all the best. Talk to you soon. Have a great day. Stay safe out there. And if you have a case, good luck. I hope you get full justice in your case. And if you are hurting, I hope you feel better. I hope you get, you know, the best medical care you can get and recover completely from your injuries, because you have to, you know, in order to enjoy life, you have to be healthy, and that's so important. Okay, everyone. Thank you so much. Have a great day. Bye-bye.